the bond. I think the issue for Mr. Garcia comes to if the court if the bond was released and then increased, I think that give me 1 second. I just want to read the case.
I understand. Questions
and if the bond was released and then increased, I think that give me 1 second. I just want to read the case.
I understand. Questions
and if the bond was released and then increased, I think that give me 1 second. I just want to read. I think under Jones, the court and also under 16.4.109, the court is able to increase the bond. I think what Jones is saying cannot happen is obviously what the court just laid out, which is the revocation and then not setting a new bond, but also revoking the bond. And then increasing the amount, I think, would also be contrary to what I think what Jones is saying cannot happen is obviously what the court because that is essentially the revocation and then not setting a new bond. But it's essentially saying that Mr. Garcia would have to post two bonds instead of just the difference cannot happen is obviously because that is essentially and I'm sorry, I'm definitely not being super articulate here, but it's tricky and numbers are not my thing, which is why I'm a lawyer. But essentially, I think that the issue is that the court can increase a bond. It's different than revoking and setting a higher bond. That's my view of Jones.
I don't know if the people have a position in terms of that issue at all, but I give you the opportunity to address it if you did.
I don't.
Right. Give me one moment. Part of the difficulty, and we've got the two cases, but there's one that's really, I think, summarizing the issues and concerns I have. It's the 19 CR case, and therein lies the major issue. It's 2021, and this is a 19 CR case. Much of the delay has been as we've been trying to get Mr. Garcia to be able to move through this process. Back in June, the competency evaluation was requested. He was in custody, I think, during that time, but I think we looked at trying to get him out. And I don't know if that's exactly correct, but I know that on our next day in July, pretrial services came in and said that Mr. Garcia removed his GPS and that he'd gone into the exclusion zones repeatedly. We had multiple failures to appear, kept trying to find ways around that, reinstating the bond, appointing a bridges liaison. We'd return the bonds to their the prior amounts, and then immediately Ms. Paycheck was indicating that Mr. Garcia was not complying with outpatient restoration and was having problems. We set that over other dates, and he hadn't engaged in restoration. And there were pretrial services complaints continuing to come in that there are multiple travels near the victim's home and trips into the exclusion zone, and one of those trips was directly to the victim's home. Basically, under those circumstances, also pretrial services said they directed him to report into pretrial services, and he refused to do so. Given the ongoing lack of compliance, and unfortunately, right at the end, there's an indication Ms. Paycheck was saying they were making some headway and moving forward, but giving all of the problems that we're having, the violations of the bond conditions in terms of entry into the exclusion zones, the lack of compliance in terms of setting up the restoration, and the fact that this case has just been going on for months and months and months from a 2019 case without any real progress or substantial progress. I am going to, and I'll make sure that the language is correct. I would say at this point, the prior bond should be discharged and released in terms of that, but I'm setting a higher amount in terms of that. It shouldn't be, the bond is revoked, but whatever the language correctly is in terms of that, I think the $10,000 bonds that are presently set in light of the problems we had are appropriate to make sure we can get the restoration done and taken care of. So that's a convoluted area, unfortunately. I think Ms. Prince, you raised good issues, but ultimately I'm going to go ahead and keep the bonds at the $10,000 cash property surety amount that I think we set on our last date on December 18th, and continue with the efforts to do it's 10,000 and 5,000. Keep those prior bonds in place and continue with inpatient restoration until Mr. Garcia posted those bonds. I'm not revoking bond, I'm not denying bond, but I'm saying that those would be set bond amounts, and if he remains in custody, that it be an inpatient restoration. Secondly, in terms of the disclosure of the information to the county court, generally when a person is incompetent, it waives the privilege in that regard, and the reports I don't think are privileged. But that's a delicate area, and ultimately I don't like putting the county court in that position of saying, well, do your own evaluation. But I think it's safer to err on the side of protecting privilege rights and confidentiality rights. I don't think they prevent the disclosure, but frankly, the county court can order an evaluation and they can get that done. There's going to be some time to get that taken care of. And I would envision the worst case scenario would be that we get the restoration taken care of and we have a new report that says Mr. Garcia is competent. And then if he wants to go ahead and approve releasing that to the county court so they can resolve the competency issue faster, that's fine. But I don't think we're really saving any substantial time for the finding of incompetency. And so rather than have the parties at this point release that record or show that to the county court, I'll rescind my prior position. If after looking at it, either of you looks and says, no, I think that here's the reason why it can be released, and both parties agree it can be released, let me know and we'll direct it's released. But today at this point, I think that the safer position is to say county court should probably at this point go ahead and order their own evaluation. Plus, I think on the GS cases, at least if it's a GS case, they have a different standard, I think, in any event, possibly, so they should probably get their own report in that regard. Other than that, Ms. Prince, preserving all of your positions and so forth, any additional, preserving the objections and the requests and not conceding to any ruling, anything else you wanted to address today?
Your Honor, my request would be to set this in a status in 3 weeks to see about transport and to see if anything has been started with custody restoration.
Let's go ahead and set a status date. We could set that for January 29th.
I can accept that. That works.
Does that work for the people? All right, so Mr. Garcia, we'll call it up again on January 29th. My hope is that we get that restoration going so that we can get this part done and behind you. We'll see you on January 29th. All right. It's coming up on 1 o'clock, and I know it'd be good if for probably all of you, but also for me and for my staff, if we can take a short recess. Was there anything we need to take up before we do a recess, though?
Your Honor, I was just wondering if I could address the individual's not here, so if anyone's here, certainly I don't want them waiting longer, but I do have a case that myself that I'm just requesting to be set for Monday. I don't believe Mr. Leidy had an objection, but the person, I told them that they may not have to call in according to the court's, approval or not, just because we're requesting a quick sit over until Monday. So I was wondering if I could address that first to see if they do have to call in.
Which case was that?
Your Honor, on Dwight Ragland, he's set for sentencing. This was kind of a rather complex sentencing issue. So we were just requesting a brief set over until Monday. I don't believe Mr. Leidy had an objection, just needed a few extra days, which Monday does provide to be prepared for the sentencing decision.
I'm comfortable with that, of saying that we'll go ahead and reset this for Monday at 1:30 if that works for both parties. I see Mr. Leidy's online. And then we vacate today. Obviously, if Mr. Ragland didn't come in on that date, that still counts as a failure to appear and so forth. But
that's fine.
Does that work for the people and the defense as well?
With that notation, yes, I don't have a problem with him not being here right now.
That does.
All right.
Thank you.
And so obviously we were not going to issue any warrant for not being calling in today or something. We'll call the case up Monday instead.
Perfect. Thank you.
All right. Thank you both.
And Your Honor, I did have Tyrone Sinclair this morning. I didn't.
Mr. Sinclair called in, but go ahead.
Yeah, so it appears that his phone, and this is Mr. Morales' case, his phone died, and I can't reach him right now. I know he called in and he said his phone was about to die. I assume that it's charging and hopefully he'll be calling in this afternoon, but I didn't know if we could potentially request to stay a warrant on this case and address it, or if the court wanted to wait till the end of afternoon docket, or kind of the way the court wanted to case his phone died.
My thought, since it's getting close to 1 o'clock, why don't we table it until later this afternoon? But since he called in, if we can get him to call in this afternoon, I'd rather not issue a warrant for anything this morning since he was clearly here. And I know there's phone issues. Obviously, if it was he hung up or the phone died and decided not to call back, that's a different issue. But I'm happy to wait till this afternoon and call it up at that point. Mr. Morales came on. Any objection to that from the people?
No, Your Honor.
All right, we'll go ahead and hold off, and certainly we won't count it as an FTA at this point from today, and we'll go from there.
Thank you. And Your Honor, I do have some afternoon conflicts. I will check in though around 3, potentially when docket's ending. But certainly if he calls in sooner, if the staff could potentially let me know just via email, and I'll jump right in.
We'll do that. If he calls in, we'll email you, and I understand that you'll be in a different courtroom at times. All right, ladies and gentlemen, thank you very much. We'll go ahead and take a break until 1:30, maybe 1:35, 1:40, but then we'll start up with our afternoon docket and try to get through all of those things as well. I'll try to be ready to go as close to 1:30 as I can.
And Your Honor, for 1:30, I've been talking to Mr. Duncan. I don't know if he's still here, but he has an interpreter matter this afternoon, and I think the interpreter was going to let the court know they were available at 1:30, but not long after. So I believe that Mr. Duncan's going to want to at least have that case called first, whether it be 1:40, but try to get that case called first and get that resolved for the interpreter.
I'll try to make sure we're available at 1:30 so we can get that done as well, get our interpreter out of the way.
Appreciate that.
All right. Thank you all very much, and we'll see everybody at 1:30.
All cops are bastards. Neither parties. All cops are bastards. All cops are bastards. Yeah. Just got 40 All right, I'm back. Didn't miss anything. Cops haven't moved. Appreciate it. All right, we're going to take a walk around to the other side. $845 billion. Good, how are you? $845 billion is the amount that the billionaires have added to their wealth since March, since the beginning of this crisis. Fucking looters! This is exceptional capitalism. It's not crony capitalism. I'll walk around to the Patriot side and I'll walk back around. Yeah. Right, cops everywhere. You can't walk down the sidewalk because it's blocked. Okay, we're on the Patriot side. They're all down on the steps. Can't really see them.
2020, Trump 2020.
Like and share the stream.
What's the event today?
There's a Patriot rally and an Antifa rally at the same time.
Where are they?
And Patriots are right there. Antifa's on the other side.
Whoa, that ought to be quite a party.
Oh, yeah.
Okay.
Pieces of shit got blocked off. You can't even go by. Can't walk down the sidewalk, which you could do an hour ago. So we gotta walk back around. You can hear the USA chant. Just heard somebody say they're getting pepper balls ready.
I know, exactly.
All right, we're back. Got the riot piggies all lined up.
What is this, another $4 million in overtime for you pieces of shit?
Share the stream.
Hobbs in his neck.
Got a lot of people up here at the fence. I'm sure they will not let them stay there long.
Did you accomplish anybody silent?
No peace. These racist cops can't be beat. No justice. No peace. These racist cops can't be beat. No justice. No peace. These racist cops can't be beat. No peace. These racist cops can't be beat. No justice. No peace. These racist cops can't be beat. These racist cops can't be beat.
No justice, no peace. No war criminal police.
These bitches on Nazi radio complaining about how there's 1,500 citizens to every police officer. There's more of us than them. The fascist regime is only upheld by the police.
with the people here.
Is that when the fence went up?
No, when I got here.
Hey, bud, brother. Al SoCal, what's going on, brother? We got a little bit of a scene here today. We got Patriot Rally over there, Antifa BLM over here, and a shitload of riot cops in between. We got a lot more Antifa than we do Patriots, from what I can see. The cops are just waiting to tear gas somebody. Okay, we're at Civic Center Park in Denver.
We have tons of food and unemployment as far as we can.
No, I'm sure you are, man. You were out all night. I fell asleep. There's the Patriot rallies behind the cops.
You guys are on the wrong side of the street. Always. Things are always brutalized to working class intentionally. To beat the shit out of the civil rights movement.
Here's the soup. Here is soup. Well, how many cops are there? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27 cops on this side of that statue. And probably that many on the other side, and a whole bunch more all back there. The LRAD is out. Sorry, phone overheated again. Really need that sun to go away. I can get a little closer and stay in the shade.
Leviticus chapter 19.
Father God, where for this is the day that you made a holy day, a Sabbath day, for what you went into the temple and you knocked stuff over and said the buildings were going to fall, and here we are 400 years in slavery now. Your word is just as good as it was back then. That's a good God. I love you. Forgive us our offenses and shortcomings and help us be forgiving of others, including the small little 3%. In Jesus' name I pray. Amen. Leviticus chapter 19. I want you to understand, verse 15, it says, do not pervert justice. Do not show partiality to the poor or favoritism to the great. But judge your neighbor fairly. I am the Lord your God. What are you doing? To the God that you trust in your money when you go to bed at night, you have no control of your heart or your lungs. I'm an RN. I did critical care and trauma. You know what I know? That's this root muscle. And to the God that you serve, you have no control over that muscle. I can't breathe. I can't breathe. And he's going to be greeting you at the gate when you can't breathe and your heart stops with the same piece of equipment that you have on your hip. God made us not to be hard, but for us to prosper. Is that prosperity on your hip? Is that prosperity? You know, God, save us free. So that who are you putting us in cages? Hey, 3%er, take a group picture, and I want all your names underneath because that's how God is going to greet you as a group and be like, you 3%, I do not know you because you were evil to the oppressed, the foreigner. Yes, you were. That's a whole scripture for that. Let me help you. Let me help you with that. You've been praying for a black Jew and celebrating him every Christmas. Black Lives Matter to you every year. This Christmas, I want you to know that Jesus flag, and y'all been praying to him all the time. You didn't even know that, but I'm help you. We're going to help you because I want you to live. I want you to live life more fully and abundantly. There's only 3% of you and a lot of us. And guess what? At the end of the day, you're going to need us. You are. You always needed us. That's why you enslaved us and stole people's land, and you're living off the pressure right now. It's okay, though. Let me show you how Jesus will do it. That's where your salvation comes from.
Nope, we're moving.
They're leaving out the back!
They're going to try to...
Can we?
Proud Boys are leaving, and they're going to try to cut them off coming out the back.
Is that everlasting life on your hip right now? Praise God. You know what, man? Your heart comes
Then why are we
and he's going to greet you with the same piece of equipment.
It's like, I don't
Share the stream. Smash that like. I've already lost my voice. Antifa on the move. Cops on the move.
Take it! I hope you don't have any kids, because there's a 30% chance that you're going to kill them. Why do you protect fucking Nazis?
Let's go back in here.
Why are you protecting Nazis?
Hold on, guys. I gotta tie my shoe.
Y'all had to call in fucking backup? Really? They're going to Gold truck for a bunch of dudes in t-shirts. They're going to 13. Your parents are not proud of you, like any of them. None of them are.
Look at all these fucking cops. Look at this fucking shit.
I just want to walk through the street.
Welcome to Nazi Germany. Nazi Germany 2020. Fuck all you fucks.
I can't wait till November when you lose and we burn you to the fucking ground. I'm talking to both groups.
You see that they're the militia, right? They're the ones attacking you.
Kill yourself.
Proud Boys rally is over there. They're going to try to get out of here.
I'm not talking to you.
There they go.
Remember, don't hydrate. Don't hydrate.
Probably about 50 of them.
I'm really surprised any of you were wearing body armor. I will say that. I thought people were pepper Wait, give me a ballpark, like 20? Like 20? What does it look like 30? I don't know, I'm not made of money. I can't keep you to bring your dildo to a fucking fight.
I'm gonna check and label the call user we have. If you're calling in from line 720 and then the phone number ends with a 62, if you could please let me know your first and last name. And I'm gonna go ahead and
Engage call.
thank you. I'm gonna get you labeled and then we are gonna be getting started here at 1:30.
Okay, thank you.
Hey, let's march, everybody! Let's march! Let's march, everybody!
Hello, this is Fernando.
Thanks, Mr. Hill. And since you're calling in from your cell phone, it looks like you're already labeled, so please sit tight.
A little chaotic here.
Didn't mean to interrupt. This is Brad Lozo.
Yes,
I
there is a
represent
lot of
Mr.
tension
Hill.
here.
So you've got me as well. There's a disposition that's ready to go forward when you're ready, folks.
Thank you.
Thank you.
gonna check another phone number. This is an area code 720 and then ends in a 14. I'm gonna go ahead and unmute you. If you could please let me know your first and last name, please.
Hi, good afternoon. This is Marshall Bright. I'm counsel of record for Kobe Telias.
Perfect. And then is your client called in yet, Mr. Bright?
He's in custody in Denver.
Okay, that's right. Thank you. I've got you labeled, and I'm going to go ahead and mute you again.
Great, thank you.
All right, this is Judge John Madden in Denver District Courtroom 4H. We're getting ready to start with our afternoon docket. I know we've got a few matters set. Particularly if there's any shorter things, are we ready to proceed on on anything?
Yes, Your Honor, I believe we're ready on the Padilla matter.
All right. And I know we have our interpreter ready. I just want to make sure that she's ready to go.
I'm ready, Your Honor. Good afternoon. Spanish interpreter Paula Balsa 7159.
Thank you. In that case, I'll call case 18 CR 1284, People versus Christopher Padilla.
Good afternoon, Your Honor. Alex Duncan for the People. I did have just one question for the interpreter. Our victim, Jorge, was supposed to call the interpreter. Did that happen?
Yes, I have him on the bridge line and I am interpreting for him simultaneously.
Fantastic. Thank you.
Sure.
Your Honor, Bradley Smith, 47590 for Mr. Padilla, who appears remotely and out of custody.
Mr. Smith, thank you. Are the people ready to proceed?
Yes, Your Honor.
And Mr. Smith, is the defense ready to proceed?
We are, Your Honor.
And I should check, Mr. Padilla, are you able to hear us?
Yes, Your Honor. Are you able to hear me?
Yes, thank you very much for checking. Oh, my camera's, well, hold on. No, let me verify. I'm just checking with our staff. Can everyone see everyone on camera all right?
Yes, Your Honor.
All right. In that case, we'll go ahead and move on with the resentencing. I know we had a stipulated sentence, but there's still some information in terms of that. Mr. Padilla, I'd like to hear from the attorneys first, but give you the last word if you wish to take it. Let me go ahead and start with the defense. Mr. Smith, anything further regarding the sentence in this case?
And Your Honor, I just wanted to confirm that the court was able to review the mitigation package that I was able to submit.
I did, yes, thank you very much.
And I will just briefly add argument to that. I certainly acknowledge that anytime we have a probation revocation, the question comes up, why would we be open to trying it again when it has previously failed? I think in this instance, as I outlined in my mitigation package, this would not be merely an attempt to try something that has previously failed. I believe that the previous PSI that was issued in 2018 accurately reflected the issues that Mr. Padilla has with alcohol. The events of February of 2020 are very serious, and it's completely understandable the concern that arises from that. I do believe that that has to, though, be weighed against the positive things that Mr. Padilla has accomplished, both on probation in this case and in his life in general. And first, I'd point to the fact that it was approximately 18 months that he was successfully completing probation from the time of the initial sentencing to the time of the violation. That now 11 months have lapsed after the events of February, and that Mr. Padilla has remained in compliance, that he has continued to have steady employment, that he is enrolled in academic classes for the upcoming semester, and most importantly, Your Honor, the fact that he has actively engaged with the CU Denver Addiction and Research Treatment Program, I believe that shows a level of initiative and stability within the community that ordering him to be reinstated on probation with strict compliance is not only the best for Mr. Padilla, but gives us the best opportunity to have him come out of the system a sober and productive individual. And I can't but fail to mention that there's also the concern of COVID placed against any incarcerative sentence, even in community corrections. So we would be asking for the reinstatement on probation. And further to that point, I would note that there are already 156 days of pre-sentence confinement in this case, which would be relevant to any community correction sentence. But I also note that having him replaced on probation kind of gives a scope for a longer period of supervision, and in my view, actually gives a higher likelihood of success than having him in for community corrections for the period of time that it would happen. So with all those in mind, I would ask the court to acknowledge that while we acknowledge the severe concerns that occurred in February, to take account that Mr. Padilla has made great strides in his life, that a incarcerative sentence, even community corrections, would destabilize those concerns and to give him the opportunity to continue to prosper by reinstating him on probation. And I do know that both his father, Mr. Rudy Padilla, and his neighbor, Ms. Denise Crowell, would ask to be heard by the court.
Let's go there at this point. Out of the two, who would you like to have speak first? And so, go ahead.
Your Honor?
Yes.
My name is Rudy Padilla. I'm Christopher Padilla's dad. I live in New York City. I couldn't be there with him, supporting him. My son had come into a lot of issues in the past, and alcohol has been one. His mother's death has definitely affected him, but I think he's in the right path. And I believe that him being in treatment is the best solution. And I think that's what he needs. And I would ask the court, and I would ask you, Your Honor, to have leniency and please see that he doesn't be incarcerated or any way that he can get COVID. And that's one of my fears. Thank you, Judge.
Thank you. And then also, do we have Mr. Padilla's neighbor as well?
And I see Ms. Crowell trying to speak. Ms. Crowell, can you unmute yourself?
Excuse me, I'm sorry.
That's all right. We can hear you now. Thank you.
Can you hear me?
Yes.
Okay. Thank you, Your Honor, for allowing me this time. I would like to just comment on Chris and I are neighbors, been neighbors for a couple of years now. He has always been very courteous to me, respectful. He has been reliable. I recently had my right knee replaced, and he has helped me with my groceries and to bring my groceries up to my apartment. Also, he's helped me with my laundry, bringing it up to my apartment. Chris has presented himself always very level-headed, very cooperative. Again, has shown respect, and he's been very reliable. And I appreciate his friendship. And most recently at Christmas, he had brought me some food for Christmas dinner. And he's been very, very nice, a very nice man to know. And I appreciate our friendship very much. He's been a very huge helping hand for me, and I think he's a very good person, and I respect him very much, and I appreciate him being my neighbor very much.
Ms. Crowell, thank you very much. Go ahead. If you have more to say, go ahead. Thank you.
Yeah, I thank you again for your time, Your Honor, that I can share my thoughts.
Thank you. Before I went to the people, I want to go back and check with one thing, Mr. Smith. I was going to ask both sides in terms of this. The revocation complaint indicated that Mr. Padilla had gone to trial on the General Sessions case, and there was a conviction there. Do you have an understanding as what the allegations were, or the circumstance was in terms of that case?
Mr. Smith, you're muted.
And you were muted. I'm sorry. Oh, here, let me get
where
that.
he was intoxicated. He got into a confrontation with.
Let me have you back up. You were muted for the first half of that. Let me have you start again. No, wait, hold on. There we go. Please go ahead.
My apologies, Your Honor. The case was that Mr. Padilla went to the Satire Lounge. While there, he fell asleep at the bar. He was confronted by the bartender. They got an argument over having him leave. The argument progressed where a glass mug was thrown, which broke. And he was then, by the bouncer and the bartender, pulled out of the bar. Denver police responded. They made contact with Mr. Padilla. They placed him under arrest. They did find a knife in his pocket. There are no allegations that he ever wielded that knife as a weapon, but it was over the length that is permissible to carry in your pocket in the city of Denver, which accounts for that charge.
Thank you. That helps me. Let me go to the people. Mr. Duncan, your position.
Thank you, Your Honor. So just to clarify again, it was a cap of 2 years of ComCore was the admission with up to 2 years of ComCore. And Your Honor, I'm going to ask that the court impose 2 years of community corrections in this case. I talked to a few different people in the case. First was Jorge Ibarra. He was one of the victims of the underlying case, and he is on the line here today with the interpreter. He didn't want to address the court, but he did tell us that from the beginning, he believed that the defendant is dangerous and needs to spend some time in custody, and that he still thinks about this case, that this is something based on the underlying facts of the case that still bother him, and it's something that he still remembers as well. We also spoke to the other main victim, Francisco, in the case, and he told us that he trusted the court to do the right thing for the revocation. In terms of the new law violation, Your Honor, Mr. Smith laid out those facts well. The only thing I'd add is that it was Mr. Padilla that did throw the glass from my review with the bartender, and then he did have that knife. There's no allegation that he used the knife, but he still had it on his person. And Your Honor, I also spoke to the probation officer in the case, Michael Barrett. We spoke about the case, and he indicated that he took over the case from another probation officer that hadn't placed Mr. Padilla on UAs at the very beginning of the case. However, the probation officer here believes that alcohol is definitely a problem for Mr. Padilla, that while he wasn't placed on UAs at the beginning of the case, that he still should have at least asked or recognized that alcohol was a problem for him. He did have a protection order at the time from this case that forbids him from drinking at all. And after the new law violation, the probation officer did put him on UAs, and he indicated that there was a positive for alcohol as well as recently as October 28th. And so with all of those facts in mind, the probation officer is still recommending community corrections in this case, Your Honor. And so that's what the people are recommending as well. It seems that Mr. Padilla has made strides while on probation, but when he drinks, he ends up doing both violent and dangerous things in the underlying case and in the new case. So, Your Honor, the people do have some community safety concerns here and think that ComCore would be the best option for him. So we'd ask the court to impose those 2 years of ComCore.
And Mr. Padilla, let me unmute your microphone. You're set for that. You don't have to say anything, but I consider anything you had to say, and you have a right to make a statement. Is there anything more you think I should know?
Yes, Your Honor. First of all, I'd just like to apologize to the victim, Mr. Ibarras. I have no idea why my behavior would fall this way. It's part of the thing that perplexes me the most, because I had been doing pretty good on probation, moved up to an unsupervised level, just that I had external afflictions that I didn't know how to cope with, other than trying to separate and disconnect myself from everybody. And my best coping method was alcohol. But Your Honor, the last time we parted ways, I'm not sure if you read any of my letters. I did the best I could with what was available to me. My mother, her estate, all my possessions were auctioned off by the city. I had to survive under a bridge for 7 months in the snow in a tent with a buddy heater before I was able to, throughout some miracle, now as a convicted felon, somehow finding residency in a decent part of the neighborhood, which is next to near impossible. I've through that journey, I used to ride the electric scooters back and forth for the said building that gave me that housed me. I used to do maintenance, landscaping work for them, and in that journey, there was actually a story done on me about a homeless man. They called him the Scooter King, that was able to go from homelessness, and I had the record number of rides in Denver for the scooters. I then was given a job as an electric scooter mechanic. That is my last job. Your Honor, this all started when I started trying to form a relationship with a girl, which is not my best area of expertise. And again, I just sort of spiraled out of control. But I am fully conscious and well aware that this behavior is completely and diametrically opposed of who I am and how I operate in the community. I think that a lot of these letters were handwritten. I think that proves testament to how I am on a normal basis. I think I'm still an asset to the community. I know I have behavioral issues, and upon this realization, I've taken the first step to put myself voluntarily into treatment. I'm in 3 groups: recovering men, relapse prevention. I'm also in the MRT group. I'm on step 3. All of my stuff is filled out up to step 3. Basically, Your Honor, what I'm asking is that you don't cause such a deviation in my life from where I've already established myself that makes it next to near impossible to recover. I'm able to function. I'm 99.9% compliant. I have been with probation. I think the records will show that. I'm currently on an ankle monitor right now. I'm on a scram monitor. I blow into a device 4 times a day. I don't think alcohol is going to be an issue. I do have control of my life. And I'm just asking that you have some mercy, that you take some value into, my life into consideration, especially with the new strains of COVID going on and forcing me to surrender my property and uproot me from the community. I just want to say that I had a meeting with my academic advisor at MSU. I'm planning on furthering my studies in computer science. One of my big things is lab cultured meat. It's a burgeoning industry. I want to get into that. I'm all about moving forward. I need to make sure that I, stay with my groups and maintain my friendships within the community in a positive manner, Your Honor. And so with that, I'm just begging you for mercy on this matter.
Thank you. Give me a moment. I want to look at one thing. Padilla, in looking through this, I know you've got a smaller history and background in Florida. There are a lot of charges that were brought and dismissed or dropped, and so I'm disregarding those. But I do pay attention to the fact that there's law enforcement contact in that regard, and there were some charges that actually went ahead on more minor offenses, certainly. I deal with people who have far more serious offenses, but some of those were smaller. The frustrating aspect of that, though, was that there was probation in those earlier cases when you were younger in Florida, and at least 2 of those cases ended up in probation, and now we've got this third one in probation and picking up a fourth one. It raises concerns for me to say that it's one thing to say I got through probation. It's another to say that you're not making any changes or that you're not changing the problems, and another problem or another offense comes up at some future point. I'll be candid, given the allegations in our case, I had concerns. I want to know more about what the charged weapon was and the circumstances. If you had been alleged to have pulled a weapon on a person or been in possession of a firearm, I would be wondering why we're doing community corrections as an option, that's the cap. In other words, why shouldn't this be a Department of Corrections sentence at that point? You had a knife. It was an illegal knife, and it's got concerns for me that you're still carrying weapons on some level, and they are illegal weapons, although it's not a firearm, and I balance those two things. I have significant concerns that our case was all alcohol driven, and part of the position of probation was this is an alcohol issue, and it was an alcohol circumstance and situation, and really we should give you an opportunity to correct that problem. And then toward the end of the probation, you're picking up a new offense that's alcohol related and alcohol driven. I think if you'd come in on that last date of the sentencing or even the plea and said, give me probation, but this is alcohol driven, which excuses it, but I'm not going to change the position. I'm going to continue to have alcohol problems and pick up new offenses that are based on alcohol. That wouldn't have been the sentence in the first instance. At the same time, oftentimes probation gets to this point and says somebody's not appropriate because they've gone through several sanctions and they just have non-compliance. I don't see an indication that you've picked up new offenses or that you're skipping tests or violating all of those issues. Ultimately, what it takes me down to is one of two positions. I think just simply reinstating probation at this point ignores the fact that you were really on probation when this took place. I know that in the General Sessions case, there's a probationary sentence that deals with that situation, but it's dealing with the fact that you were violating this probation. Just simply saying, well, let's just reinstate probation is the effective equivalent of saying, let's just drop this. You go ahead and handle the probation in the other case, and it'll run concurrently at the same time. Normally, I'd go one of two directions, and I would pick the one, but under the circumstances, they raise different issues. One direction certainly is I can say I'm going to reinstate probation, but with 90 days in jail as a condition of that probation, starting today in terms of the 90 days. It doesn't have to start today, but in other words, it's 90 days, not minus any time served. It's just 90 days. The second is, given the fact that you didn't have other violations, you didn't have new offenses, you weren't skipping tests, you did have the one offense, but it didn't involve a handgun or those issues, and it was 2 years into that toward the end. I don't think that I would want to do the full 2 years of community corrections, but I would instead potentially consider a year in community corrections minus the time that you've already served, which is substantial. It's 156 days, and so you've already served a lot of that, and that earns a different level of earned time. It impacts you the most dramatically in that regard. And so I would be willing to say, if it was coming down to a position of reinstating probation and 90 days in Denver County Jail, or a 1 year sentence to community corrections minus the time that you've already served, if you think there's a position that you think would be less disruptive to your life and you'd be more likely to succeed on, I'd put a lot of weight on that. I don't always give people the option for their own sentence between choices, but given the success you did have on probation, I think I'd rather go with something that, with your insight, you're more likely to succeed on. Did you want to talk at all with Mr. Smith before you make a decision? You don't have to tell me that you want one or the other. I can make the decision, but I would certainly hear your input in terms of if it was coming down to regranting probation with 90 days of jail or doing the community corrections for 1 year minus the time that you served. If there's one of those that between you and Mr. Smith, you thought was more appropriate, the lesser of two evils, so to speak, I would weigh that as well. Did you want to talk with Mr. Smith about that?
Yes, I would, if it's not too much of an inconvenience.
It's not too much of an inconvenience, and plus it's important. And so what I'm going to do is I want to shift the two of you over so you can have a private discussion. I'm going to shift you into what we call a breakout room. As soon as I find the other one, hold on a moment.
Your Honor, I'm also fine just calling him and just muting and stopping our video. I think that might
we can do that, or I was going to say I can move you right over to a breakout session right now so you can talk to face, and then when you're done, unclick that and come right back in if that works for you.
Understood, Your Honor. We can do that.
Let's go ahead and do that.
Your Honor, the only thing I'd note is that our interpreter does have to leave at 2:30.
All right, so please don't take past 2:30, but I'll shift you both over to the breakout session, and when you're done, if you come back in, we'll finish up the sentencing.
Understood, Your Honor.
And
Your Honor, we are ready on number 38, the Dolloff matter.
All right, give me one moment.
And Your Honor, we also have, I believe Mr. Sinclair has also called back in as well, who is a morning matter.
Excellent. I think the Dolloff matter will be very quick. We'll also call on Mr. Sinclair. For our interpreter, feel free to relax for just a moment. We'll get that called back up, and we will definitely let you go by 2:30, if not well before that. Let me go ahead and call, as we're sitting here, Mr. Dolloff's matter, which is case number 38 on the docket, 20 CR 6007.
Zach McCabe and Austin Leidy for the people.
Good afternoon, Your Honor. Doug Richards and Kristen Frost on behalf of the defendant who appears on bond and is seated to my right.
Thank you. We're set today for the preliminary hearing, but I've heard there may have been some development. Where do we stand today?
Your Honor, we will be waiving a preliminary hearing. As the court is aware, this is a self-defense case. The law does not permit us to raise self-defense in a preliminary hearing, and that's something that the jury will decide in the future in this case. Therefore, we think it's probably in everyone's best interest to focus on the trial and to continue to head in that direction, and we will be waiving our preliminary hearing.
And I think that makes some sense, as you've described that precisely at a preliminary hearing, self-defense is not an issue, and I would have to even disregard information regarding that. And so when we're not having a productive preliminary hearing that's not serving its purpose, it makes some sense to say let the parties move on to actually resolving or dealing with the case. So it doesn't have to be a resolution by any means, moving toward the jury trial and so forth. Given that, I'll accept the waiver of the preliminary hearing. I think it's appropriate under the circumstances. Depending on the defense position, let me check our next position, but do the people have any record you wanted to make at this time?
No, Your Honor.
Let me check with the defense. I've had cases where we said we're ready to move ahead. We can handle the arraignment at this point, reading of any charges if appropriate, entering a plea. I've also had positions come back and say that was not our focus for today, so we'd like it set for an arraignment date. How would you like to proceed?
Your Honor, thank you. We are going to ask to set it for an arraignment in 30 days or so.
All right. Any problem with the timing for the people in terms of an arraignment date?
No, Your Honor.
We could set it for February 8th for arraignment if that works for both of you.
Just check.
Your Honor, this is Austin Leidy for the people. Would it be possible, I am set in two different courtrooms, assigned to two different courtrooms. Would it be possible to do either the week before or the week after that? I'm assigned in courtroom 4G that week.
Let me check. The 15th, the court's closed, I think it's for a holiday session, but we could do February 1st or we could do February 5th if either of those dates work for the defense and the people.
Or, Your Honor, would the 16th work?
Unfortunately, we're not in session in terms of docket sessions during those days. It's normally reserved for trials. It's not being done that time. But I can't guarantee that Judge Whitney is available in terms of that date, and he'll be handling the arraignment. So we probably have to do the Monday or Friday before the 1st or 5th, if either of those would work.
Sorry, is the 19th available if they wanted to go after?
Let me check. That works as well. We could do the 19th.
That's fine with the people. Mr. Lighty?
Your Honor, that's also acceptable for the defense.
All right, we'll go ahead then and set it for an arraignment date on February 19th. Does 10:30 work for both parties?
For the defense,
It works for myself.
It works for me, thank you.
All right, it looked like that worked on all ends, so we'll go ahead and say February 19th at 10:30 for arraignment. Let me check with the defense. Anything further today that you wanted to address today?
Yes, Your Honor, there's two matters. One, there is an agreed upon bond modification. And I don't want to get ahead of the people, but I understand that there is VRA compliance. The defendant currently is on GPS with maximum home confinement, and by agreement, that will be stepped down to just GPS.
For the people, either Mr. McCabe or Mr. Lighty, is that your understanding and agreement as well?
Yes, Your Honor, and we are in compliance with the Victims' Rights Act. I did consult with the victim about that modification.
And so I want to make sure I'm on the same page. It would take this down, I think, from the maximum level of supervision, which is effectively, as you've mentioned, in-home detention or in-home confinement in effect. And I think it takes it down, I believe, to the intensive level, which is GPS monitoring. There's certainly other pretrial service requirements in terms of checking in, but it would just be GPS monitoring. Is that what both parties are contemplating?
Yes.
Yes, Your Honor.
All right. Given the stipulation and given the circumstances, I'm aware of some of those from our prior dates, I think that's appropriate as well. So we'll go ahead and reduce it to intensive level supervision with the GPS requirements, but no requirements in terms of basically in-home confinement.
Thank you, Your Honor.
Thank you, Your Honor.
The only
Anything
other
else from
matter,
Good. Go ahead.
Yeah, the only other matter was we had filed a number of motions when we filed our entry of appearance. The people filed an objection to a discovery motion earlier in the week, and last night we filed a reply brief. My only record I wanted to make is we didn't have any further record. I know it's not on calendar for today, so I'm not asking to make arguments on it, but if the court was asking for that, I would stand on the record and I have no further arguments to make.
I appreciate that. And I'd seen that it had been filed, and in the document preparation, I had not yet read the people's response, but I can take a look at that as well. And I'm comfortable with the motion stand on their own, but I should check, did the people want to make any additional record regarding the issue?
Just real brief, Your Honor, in regards to the reply filed by the defense. And I would just point the court, People v. Velasquez is cited. It's VLASSIS 247 P 3rd 196. I think it's on point and in favor of the people's argument as to the request for notes of all investigators and prosecutor notes from witness interviews. And to a certain extent, it's also on point as to Mr. Dolloff's request for the prosecutor's emails, voicemails, and text messages between the district attorney and investigators. Additionally, Your Honor, in regard to the request for updated resumes and prior testimony here, history of witnesses, we are objecting to that. Although, as this court knows, our standard practice is to provide a curriculum vitae for all endorsed experts. Prior testimony history is not always available, and sometimes, depending on who the expert is, a curriculum vitae may not be available. The authority cited by the defense is inopposite to the material requested here, and in one instance is the Trattler case, TRATTLER, is a civil case relevant to the rules of civil procedure, Rule 26, not Rule 16 of the rules of criminal procedure. In regard to the request for exculpatory evidence, at the outset, we would note that we will comply with Rule 16 as well as Brady and Giglio, and will provide any exculpatory evidence. The objection to that one narrow request for prior misconduct is that some of the prior misconduct may not necessarily implicate exculpatory evidence. For example, an officer is required to wear his or her seatbelt while he is working, and if an officer somehow suffered in a department administrative action for not wearing a seatbelt, I'd fail to see how that would be relevant as to exculpatory evidence or in a case. As I mentioned, I think it's improper for us to have to provide text messages or emails for some of the same reasoning as the Velasquez court, but also as outlined in the motion. The last is a request for metadata, and we don't object. Well, we do object to that being an order of the court. I think the parties have some disagreement about what is being provided as far as metadata for the electronic discovery. So I would suggest that the parties can kind of work through that and figure out what metadata they believe is missing, because a spot check on my end showed that metadata had been provided, but there's a lot of electronic discovery in this case. So I think the parties can probably work through that and figure out what is and what is not being provided. I will state affirmatively that our office doesn't scrub any data or metadata from video recordings or electronic recordings. So it should be as we get it, and we're not affirmatively removing any information. Other than that, I will stand on the response.
All right. And that doesn't necessarily require one, but since it is the defense motion, if there's any surreply that you wanted to address in terms of the verbal issues, I'll let you go ahead.
Your Honor, I mean, most of those, the arguments that Mr. McCabe made are addressed in my brief. In fact, the Velasquez case that the people are relying on is actually prominently cited in paragraph 3 of my brief. So we seem to be on the same page in terms of the law. And in terms of the metadata, I agree that we can probably work that out amongst ourselves. We've already been emailing about some of those issues. The only reason I addressed it in the reply brief is because it was in the objection and response in opposition to our discovery motion. So with that, I think our brief stands on its own, and I would rest on the record.
I appreciate that. What I'll do is I'm going to go ahead and try to one moment, I want to look at one thing. I'll try to get that ruling out hopefully this weekend, so it's not sitting in limbo until Judge Whitney comes in terms of that, so that you can process with the discovery. Velasquez is a case I'm very familiar with, but I want to read through the arguments both of you have made. Trattler, frankly, although it's a civil case, I retried Trattler or presided over that, so that may be the ruling from either the case I knew forward and backward, or it may have been the appeal on the case after I presided on that. So I'll look at that as well. But I don't think it's going to take a long time to get that order out, and I'll try to have that out by Monday. Other than that, I think we're in good shape. Let me just check with the defense. Anything further?
No, Your Honor. Thank you.
And for the people, anything further before we recess today?
Not for the people, Your Honor.
All right. In that case, then we'll go ahead and set this over for our next date in February. Bond will continue. The preliminary hearing, we waived at this point. We'll set it for arraignment. This will probably be my last appearance on the case with all of you. Good luck. I know Judge Whitten will be ready to go on the case, and good luck.
Thank you,
Your Honor. Honor, good luck to you.
Thank you as well.
Thank you, Judge.
Thank you.
Thank you, Judge. It's been a pleasure working with you.
Mr. McCabe, thank you as well. It's been a long time. Thank you. Let me go back to Mr. Padilla's matter, since I know Mr. Padilla is available and our interpreter has a narrow window. Let me go ahead and recall that. Let me get back to my notes. It's 18 CR 1284, People versus Christopher Padilla. Let me just check first, Mr. Smith, and I certainly would not ever force someone to make the statement, but was that an issue that Mr. Padilla wanted to address in terms of his thoughts on those options that I'm looking at?
Your Honor, it would be Mr. Padilla's preference for the year of ComCore with the credit for time served. We would be hoping that we could get a remand date and do the screening out of custody, if that's practical.
All right. What I'll do, and I appreciate that,